Hello.
Shellinga, Peter?
Speaking.
Hi, I'm trying to call you it's Tim and Small Claims calling.
Yes?
Or have you called into the conference line?
No, I was told that somebody would call me.
Okay, because we have to call in on the conference line, so if you just give me a quick second, I'll call you back, and perhaps I can put you on speakerphone.
Well, nobody told me I had to call a conference line. I was told somebody would call me at my number.
All right, so what I can do is I'll just put you on a quick hold, and I'll get right back to you, okay?
Thanks.
Thanks.
Well, that's a great way to start the day. Hello?
Tim and Small Claims calling you?
Yes.
Okay, perfect. So now that I have you on the correct line, what I'll do is I will be bringing everybody in, and you guys start, all right?
Okay, thank you.
Oh, don't go anywhere.
We're on the record. Good morning, Madame Judicial.
Good morning.
Good morning. This is Deputy Judge Pierre Brunet, and present in the room with me is Pierre Belanger, who is the counsel for the defendants, and there's also a court reporter. This examination, conference, is being recorded. I reviewed the file before we sat down, Madame Judicial, and I just want to make an observation. I see that a claim was issued back in April of this year. It was served in early October. That a defense was delivered at the very end of October, on the 31st of October, and on the very same date, the court issued the notice of settlement conference for today. Subsequent to that, you issued an amended claim on the 10th of November, and according to the materials in the file, it was served on the same day, but no defense has been delivered yet to that amended claim.
Right.
I am also aware that there's a companion action that's ongoing in the Helena and Perry Zay matter, and it was issued at the very same time as this claim. And I'm aware that there's been an endorsement made recently when a motion was heard in that file where it was transferred up to the Superior Court of Justice, and Deputy Judge Young provided his reasons for that motion.
Okay, well, prior to us getting a little too far into this, the other action has no bearing on today's settlement conference, number one. Number two, I was hoping to use this time off the record to deal with an obvious issue I have with respect to Mr. Lambert-Bélanger representing the defendants, considering the nature of the claim and the witnesses I intend to call, which include his father and two of his family members, and his uncle was the judge in the matter. I feel strongly that, when I served the proposed witness list, that maybe it would have given him an opportunity to comply with his moral, ethical, or professional obligations. So I'm in a position right now that, I'm willing to offer the defendants to file an amended defense to their action and to find themselves another solicitor, or in the alternative, I could bring a motion to recuse Mr. Lambert-Bélanger. I don't feel comfortable really having any kind of discussions at this settlement conference here without the actual defendants being present and being off the record, So I don't really feel like we could go forth today with anything.
The challenge I have is that there's no defense of the amended claim, so that's
exactly
already an obstacle to move forward today. But I raise for your benefit, Madame Judicial, my observation that both your claim against the Timmins Police Service and against the Parizet law firm arise from the same occurrence.
No, they do not. They arise similarly into the privacy breach aspect of the claim, but the creating of the false records for the purpose of releasing them, I don't think Mrs. Parizet had any involvement in that.
But they arise from the same occurrence. It's a disclosure issue that occurred, and the claim is against Parizet for some damages, and there's a claim against the Timmins Police Service for another form of damages, but they arise from the same occurrence. And I believe that there's some benefit to all those claims being heard at the same time.
I do not, because what Ms. Parizet did with her request for the information and what she did with it afterwards, held on to it for a year and a half. That was her doing. Timmins Police had nothing to do with that. But the intent for the Timmins Police to release them, considering that many of those records were fabricated, that's totally separate and apart than what Ms. Parizet did. And again, I'd like to go back to what I said earlier, that I'm not really interested in discussing too much of this claim today off the record without all the parties being present and with Mr. Pierre Lambert-Bélanger, who's in a real conflict of interest to be presiding over this matter. Really affects my, living in small towns or small communities shouldn't affect my right to have access to impartial justice without all these conflict of interest or this circle of enrichment going on. So perhaps we'd like to maybe adjourn the settlement conference to a later date to allow the defendants to file an amended defense, considering I just filed an amended plaintiff's claim, and then we could, if they would like to have this matter joined to another claim, then they're more than welcome to bring their motion to the court, because I'm not ready to deal with any kind of a procedural issue at a settlement conference.
Well, I'd like to hear from Mr. Lambert-Bélanger your suggestion, firstly, that he's in conflict and his position with respect to the delivery of the amended statement of defense.
Well, first of all, the issue of conflict, I really don't understand the basis on which we're asserting that argument at this point, other than the fact that I saw my father's name as a potential witness. There's nothing in the claim that suggests how my father is even remotely connected to the claim and the ties. Be able to see how he can remotely to this claim. So it's certainly not agreeing with my
well, you know, your father and your aunt and your cousin, you know.
Give him a chance to speak to
The motion
Oh.
is not to that effect, though. If you were to take a position, I actually see no basis at all for that at this point. Well, the amended claim was served shortly after we filed our defense. Originally, I believe took the position that our statement of defense probably did not amended. Reviewing the claim now, quite possible that we will file an amended statement of defense. The original claim dealt with the issue of improper disclosure. Second claim appears to have false records being created, and originally thought the defense had covered that issue as well, but it may not have done so fully. So I expect that we will file it shortly.
Madame Gélina, there's considerable discretion that's granted to a judge in these types of circumstances in order to achieve a result which is in the best interest for the administration of justice. I've read your amended statement of claim, and I've noted a number of allegations that are made not only against the Timmins Police Service, but against third parties arising from the same occurrence. And the matter involving the Parise law firm is definitely something that arises from the same set of circumstances. They share common issues of law, and I think that it's important that courts be used efficiently and that the claims be combined. Now, in order to do so...
They're actually under two different laws. Mrs. Petitze obtaining the records under a court order under the Child Family Services Act, that's a statute that guided her. The release of the records by the Timmins Police, that was guided by the Municipal Freedom of Information Act. So there are two areas of laws that are completely different. The intentions of both parties were completely different. I don't want to start involving Ms. Petitze in the false creation of records by Timmins Police with the intent to release them to her. I don't think Ms. Petitze had any involvement in that. That's the reason why I didn't join the claims together, because the allegations being made are completely separate and they're in reliance to separate laws that guided their obligations.
I appreciate that your claims may be different under different laws, but they arise from the same disclosure incident, ma'am. It's a consent that was used by Madame Petitze with the Timmins Police that resulted in some records being released, which take objection to. And you've brought a claim against both of them to address that. You've done them separately because you believe that they should be framed separately because they're under different laws. But clearly, they arise, and you've conceded that in your submissions, from the same disclosure incident. So in the circumstances, I think it's a more efficient use of the court's time that these claims be joined. That this claim be joined with the Judicial claim,
Well,
and that this claim be transferred up to the Superior Court of Justice at Cochrane.
Well, see, that's the issue I have, because there's no really inherent jurisdiction for a small claims judge to transfer a small claims action that is properly framed before the small claims court to the Superior Court of Justice under Section 110(1) of the Court of Justice Act, because we're here in the small claims court. We're not going to the Superior Court. I've already appealed Mr. Justice Young's order transferring the matter to the Superior Court without jurisdiction, and that matter is actually sitting in the divisional court right now. So we're not joining the Timmins Police action to the Petitze action and transferring it to the small claims court to the Superior Court without any party bringing a motion And I'm not willing to deal with this today at a settlement conference with a solicitor who's in an overt conflict of interest. So we're not going to be dealing with this at a settlement conference, unfortunately. And I'm quite knowledgeable in the law, whereas there is no law that allows a deputy judge of the small claims court to transfer my matter from the small claims court to the Superior Court of Justice, unless I was asking for like $50,000 and it really didn't belong in the small claims court. But without my consent and without any of the parties bringing any motion to transfer my action to be joined to another action and give me a proper opportunity to respond on motion, it's not even going to be done today. Otherwise, I'll appeal the same order like I did with Justice Young's order to the divisional court as well. We're not going to be playing the game of let's corner her with a conflict of interest and in an abusive fashion without following the rules of law and let her fend for herself, because...
I'll refer you, Madame, to Section 25 of the Courts of Justice Act, which gives the judge discretion to make an order which is just and agreeable.
Well, it's not agreeable, and it's not just, and it's not made in good conscience.
Rarely do people come to court and walk away happy, ma'am.
Well, that's why you bring your matters that are well within the small claims court, as per Jones versus Sings, that confirm that torts of invasion of privacy and intrusion upon seclusion can be brought in the small claims court. The appeal court confirmed that my claim is properly framed to be dealt with in the small claims court. And actually, I've had to let go of a lot of other issues of liability of the Timmins Police, such as, unlawful use of force, illegal search of my home, and other things to bring this claim within the jurisdiction of small claims court. So if any party wishes to go to the Superior Court and bring it there, you could guarantee you my claim's going to go up by quite a few $1,000s.
That would be your option.
So then a party could bring a motion to really think about their position right now as far as this privacy breach goes and deal with the fabrication of the false records that were intensely disclosed to third parties. They could deal with what they want to take a responsibility for there and fix that in the small claims court. And if they want to bring it to the Superior Court and open up some floodgates, we could do that too. Because you know what? I've got nothing left to lose, right?
Ma'am, you're suggesting that we don't have the authority to make the order that I'm proposing to make, and I'm drawing your attention to Rule 1305 of the Rules of Small Claims Court, which gives us the authority to make that order.
Yes, upon a motion being brought by opposing party to...
Nonsense, ma'am. And Section 110 of the Courts of Justice Act gives us the power to transfer the claim. It's very clear for me that these two claims...
Which rule are you relying on? Under Rule 13? Under settlement conferences?
Yes.
Right. Are all the parties here today?
Ma'am, I'm going to make the endorsement, and I'm going to get the court clerk to provide you a copy of the endorsement. My decision is clear.
Are you in a conflict of interest as well? I haven't taken the time to research, but...
I have no clue who Chantal Gélinas is. I've never dealt with Chantal Gélinas.
How about Charles Lambert Bélanger?
And therefore, you're talking to the deputy judge now. And accordingly, I have the authority to make this decision. I don't have a conflict with you. And so the matter will be combined with the Gélinas and Parizet claim. There'll be an order made to consolidate.
I'm not sure if you understood, but I've appealed that order.
I understand that. Doesn't prevent me from making this order. And accordingly, I will combine this claim, I'll consolidate this claim with the Gélinas and Parizet claim, which is Small Claims Court File 16-0000093-00. The claim will be transferred to the Superior Court of Justice at Cochrane.
Oh, you're going to transfer jurisdictions as well?
No, the Superior Court of Justice at Cochrane sits over the Timmins Court also now. It's a district of Cochrane. The seat of the court is in Cochrane. But there's an administrative office in Timmins for the Superior Court of Justice, and there's also one in Cochrane.
So why don't we transfer it to Halebury or North Bay?
Well, that perhaps would be an option of yours, ma'am. I'm transferring it to Cochrane. That's where the other one went. I'm keeping it in the district of Cochrane because the same occurrence. They share common issues of law, and make this order promotes a convenient administration of justice, is in the best interest of all that they be combined and that it move forward in such a fashion. And accordingly, I'll prepare an endorsement on that basis, and it will be forwarded to you by the court. Your amended statement of claim will follow this file to the Cochrane file. I can confirm that the affidavits of service for your amended statement of claim are in this file. I know you sent correspondence to the court with respect to that. And
well, I'd like to raise an issue then. If you're making this order today to transfer it, then that does not give the opportunity for the defendants to file an amended defense.
yes, they can.
Well, then maybe I'll be bringing a motion to strike out their amended defense in the small claims court. So which are we going to go first? Or are we going to allow them to amend their claim and give me the opportunity to bring a motion? Or are we going to transfer it to the small superior court and not give them the opportunity to?
Who are the claimants? Why would they amend their claim?
They just said they want to amend their defense.
No. You filed an amended claim, and I said that they can file their amended defense, and their amended defense will follow the file to the Superior Court of Justice.
Well, I will be bringing a motion to strike out their amended defense and their defense in the small claims court before it gets transferred to the Superior Court.
Okay. Is there anything else you'd like to add, Matt, for today?
I brought and raised the issue of Pierre Lambert Belanger acting for the Timmins Police and the Timmins Police Services Board when he knows his father, his aunt, his cousin, and his uncle are all involved in these proceedings, and I will be raising the issue of my disagreement with the Timmins Police from...
to bring that motion anyhow. You have to bring a motion.
Oh, I will be. So, if they're going to be filing an amended defense, then I should be given the opportunity to also continue in the proceeding. Because it's not just going to be like, we're transferring your claim to the